it's very clear that when we perceive the idea of separation of power, Montesquieu's view on this regard, John Locke later on or before that referred to this, and other scholars also talked about that judiciary should be an independent structure. There should not be overlapping in judicial functions. There should not be external intervention into judicial functions. So independence of judiciary emerges first. Why? Because of the neutrality which is required in the judicial system. A neutral judiciary is required. Why judiciary should be neutral? Because first of all, judiciary is very important for perception of democracy. Democracy as an idea depends on how people perceive about state. So people are perceiving state to be serving public interest only when state looks after larger public interest, welfare of people, and does not take into account the narrow personal interest. So country is democratic if it serves everyone. That is why people elect their representative to form government. Otherwise, if people are not electing people to form government, then monarchy will be there. A monarch will exist and monarch will be serving interest of the king, family members of king, close associates in the king's power structure, friends and relatives of king. But democracy means the people's government. It's of the people, for the people, by the people. Now this perception depends on what? State serves public interest, and judiciary is a very significant pillar which ensures that state functions in the interest of society, in the larger public interest. So neutral judiciary, a body is needed. Like suppose a legislature may make law to serve interest of politicians, to serve interest of bureaucrats, to serve interest of certain elite class of people. Or the executive government may run the state in such a way that it serves interest of few people. There is possibility. Now if it happens, then who will be present? Who will try to make state serve welfare, achieve public interest? Who will try to streamline government for larger public good? But there must be a neutral organization, there must be a neutral structure, there must be a neutral body which can achieve this goal. So first of all, independence of judiciary emerges from the need for neutrality. And why neutrality needed in judiciary? Because it develops and strengthens perception of democracy. Second, so public perception gets stronger that it is democracy, it will serve larger public interest because there is someone who can put checks over. Second, practically judiciary balances the misuse of power, abuse of power. Practically this is done. So judiciary, a neutral judiciary can balance power or use of authority. Judiciary can balance power or use of authority. Means judiciary can prevent misuse prevent misuse or prevent abuse of power. That judiciary can do. Only when judiciary is independent. Otherwise, there will be legislature with whom judiciary is binding, connected, dependent. The legislature will intervene, executive will intervene. They will not allow checks and balances. So, judiciary can balance power. Third, it develops confidence of people. Popular confidence is strengthened, developed. The people are fearless that if something wrong is happening to them, they can approach court. And court is neutral. This is not possible when court is aligned with bureaucracy. Then bureaucracy exploiting citizen, oppressing citizen approaching court, court takes position favor of bureaucracy. So it develops confidence in people, confidence of the people. So it's a tool. When confidence remains in people, people will not revolt against state. People will accept the state. Legitimacy of the state will be provided. Discontent will not come in the people. It can prevent anarchical situation. So this confidence development is not simple thing. So it this particular idea, it prevents anarchy. It prevents popular revolt. It brings harmony. Harmony is ensured. So a neutral judiciary can strengthen democratic perception, can balance power, or can prevent misuse of power, can provide for abuse, can check the abuse of power. It develops confidence in the people. And it is only neutral judiciary which can provide justice. That suppose two parties in conflict, one party deserve a civil claim of a property. There is a matter of family violence, domestic violence. Two parties are there. Woman is the victim. If judiciary is not neutral, judiciary cannot give justice to victims. And that is very important. It's related to preservation of rights of the citizens. It's related to dignity of men. So judiciary can bring, apart from these three, a neutral judiciary can bring justice in the society. How? So it can protect rights of all. It can satisfy, redress the victim, punishment to culprit. So that is a very significant task, and a neutral judiciary can do this. These three things we discuss from the perspective of neutrality of judiciary, from the perspective of state, like from the perspective of legislature, executive. And this we are talking from a neutral perspective, a general perspective, the neutrality of the judicial system. So Why independence? Independence means nobody is controlling, nobody is making judiciary subordinate to itself. That means when we talk about independence of judiciary, we are talking about the neutral judiciary. And when we are talking about neutral judiciary, why a neutral judiciary is needed? Because of these reasons. Clear? One more factor which in case of, if we talk in context of India, more factor is there which demands neutrality of judiciary, which demands independent judiciary. This case is very specific to India. Apart from these factors, one case is very significant and that case I am discussing here from the perspective of federal power. So India is a federation. In case of India, India is a federation and federation has certain characteristics. I will discuss this in our unit 6 of paper 2, state government and administration. So India is a federation and there are few fundamental characteristics of federation. First characteristic of federation is that there should be 2 units of government. That 2 units is central state or union state or central provincial. Name is different, nomenclature is different, but idea is same. So India is a federation, US is a federation, Canada is a federation, Pakistan is a federation. A federation has 2 units of government. Number 2, second feature of federation. Both units derive their power from same source. Same source means India's union government, India's state government, both are deriving power from Indian constitution. If I talk about the local governments of UK, in UK also, in England also, there is 2 units of government, central government and local government. But UK is not a federation. It is a unitary type. Why? Because in UK, the local governments are deriving power from union government, from central government. And in case of India, we have state governments are deriving power not from union government, they are deriving power from constitution. The constitution lists the subject. We have article 245, 246. And based on that, there is a schedule 7, which provides for union list, state list, concurrent list. Originally, union list had 97 subjects, state list had 67, and concurrent list had 44. So union state, their power is listed in the constitution, division of power is there in the constitution. So India is a federation. The federation has one characteristics, that there should be 2 units of government. Second characteristics, both units should derive power from the same source, that is constitution. And imagine, suppose there are one subject like the defense. The defense and external affairs are union subject. The defense is a union subject and state government start developing its defense establishment, start raising its forces. And state says it is my right, we also need it. Center says no, it's our right. Then is it possible that center and state start fighting? Is it possible? In a family, the headman is fighting with one of the members? Is it logical? There is need for a neutral judiciary. There is need for an independent judiciary. A judiciary which is not controlled by union and definitely not by state. Judiciary is independent, then if center and state is fighting, judiciary can intervene. And it can ensure what constitution says. It can ensure what is the area of legislation and execution, administration of union, and what is that of state. The third characteristics of a federation is the presence of an independent judiciary. So federation is having some characteristics. In India, federation require should be a neutral judiciary. So federation requires one of the central feature. One of the central feature that is very essential, indispensable. You can't dispense it, you can't remove it. Unavoidable. Indispensable feature, that is independent judiciary. So if there is a conflict between union and state, who will resolve it? Then judiciary can resolve. Now why judiciary? Why judiciary? If you are writing about general answer, then you can write any of these points. And you can take point of view from the perspective of India also. You can add one more. Federation requires an independent judiciary. Got the point? So it is the point concerning independence of judiciary. Why independence of judiciary? This we have discussed here. Now, how independence of judiciary is ensured? Let me add some slide here. How independence of judiciary is ensured in India? How independence? First means judiciary is not depended on union or state. Not dependent on legislature or executive. There should not be any opportunity available with the union or state government, either parliament or the ministries, to direct and govern a judicial functioning so that judiciary loses its neutrality. So this opportunity should not be available, then judiciary is independent. Opportunity is there and union can regulate the functioning of judiciary, neutrality get lost, then judiciary is not independent. So how this is secured? First of all, first thing, a general point, a very important point here, that judiciary derive its powers from constitution. And definitely in a constitution itself, the independence of judiciary is mentioned. Independence secured. Constitution itself secures. First of all, I shall mention at the very start here that an organization, a body is mentioned in the constitution. Why? To make that body more independent. Because amending the constitution is very difficult task. If an organization or body is not mentioned in the constitution and that body is created by law, so parliament can pass a law by simple majority and can abolish that office, can reduce their power, can bring them under the control of one government, may not provide them financial security for better governance by passing law. Like we have TRAI, the Telecom Regulatory Authority of India, TRAI. The TRAI is created by law. Parliament can amend law concerning TRAI and can change its power position, change structure, can abolish itself, this office. Same thing is true for the Central Information Commissions or State Information Commission. Recently in 2019, Union passed amendment to RTI Act 2019. So this amendment to RTI Act took away so many powers or autonomy of CIC. This question was asked by UPSC in its mains examination of GS. So if it is created by law, law can be easily amended. Simple majority is required. If it is not created even by law, created by government orders, then what happened to planning commission? It can be easily abolished. In future, new governments may come, they can abolish Niti Aayog and create again some new body. But when it is mentioned in the constitution, this body to be removed, its power to be altered, conditions etc. of the service of the members of that body cannot be easily altered, cannot be easily changed. It required constitutional amendment for which Lok Sabha, lower house, popular house, it should pass it by 2/3 majority, members present in voting or majority of membership of the house. Same should be done in the Rajya Sabha. It's a very difficult task. It's a very difficult process. So a body finds its mention, it's in the constitution. This itself secures independence. Okay, so I am writing here a body finds its mention in the constitution itself secures its independence. Okay, the judiciary is mentioned in the constitution itself, its independence. Apart from that, there are various constitutional provisions, like constitution secures its independence. How constitution secures its independence? Let's discuss these points. So point number 2 to mention here. Point number 2 to mention here. Removal of a Supreme Court or High Court judge is difficult task. How it is difficult task? Because it requires 2/3 majority of members present and voting, and half of the majority of total membership. That we call it spatial majority. Spatial majority is required. Very difficult. So removal of judiciary must be addressed by both houses of parliament by spatial majority. Then only executive or president can remove the judge. Third topic is very controversial. It's related to appointment of judiciary in case of India. This is not as per constitution, but as per convention. That is why I mentioned later here. It's not as per constitution, but as per convention. A judge is appointed in case of India. Earlier, the president could appoint a judge of Supreme Court and High Court. And for that purpose, president had to consult the Chief Justice of India. But a question arisen earlier that the advice taken from Chief Justice, is it mandatory? Is whatever advice Chief Justice gives to the president, is it mandatory, binding? If president appoints, it means council of minister appoints. But president takes advice from Chief Justice, and this advice can be in the form of, there are two words mentioned, I am referring here. There is a word consultation. In consultation with, and in concurrence with. Or due concurrence with. In consultation with means consultation is taken, but advice is not binding. So here advice is not binding. Consultation done, it's upon president to accept or reject. But in concurrence with is what he says as per that. In concurrence means advice is binding. That controversy was there, and we can recall there was in 1975 during emergency, pre-emergency period, Rabi Ray was appointed, A.N. Ray was appointed Chief Justice of India, and 2-level seniority was lost. Means there 3 times it happened in Indian system that a judge without seniority became Chief Justice. And A.N. Ray became very controversial person during emergency, because A.N. Ray had I will refer this in judicial activism point also, but again, A.N. Ray was appointed. Indira Gandhi wanted simply her choice of judge, so that any matter against her, like Raj Narayan case was pending that time. So many cases which came against government, especially Indira Gandhi, starting from that nationalization process, when case 1 and judgment came after 4 years of nationalization of banks and mines, 1973. So Indira Gandhi wanted that judge of her choice, so that judgment comes in favor of the government, and government can do anything, achieve socialist goal, or centralize, concentrate power, whatever the willingness. So A. N. Ray was appointed by skipping 2 levels of seniority. It again happened. Justice Khanna was eligible and some other judge was appointed. I can't recall his name. So, so many, 3 times it happened. Now, judiciary found that judiciary is ignored and executives are transferring. It happened in an emergency period. Recently, one High Court judge retires. Recently, sorry, gets transferred from Kolkata High Court to some other High Court. Justice Chaudhary, he said that 48 judges transferred as per Collegium's advice. I can recall the emergency period when 26 judges were transferred at one go by executive decision. So this is the rise of judicial era. Recently, 3 days back. So it's a rise of judicial era, that judiciary is Collegium is deciding where to transfer judges, and in one go they are deciding transfer of 48 judges. That is good. And emergency period, judges were transferred by executives at one go, not for judicial purpose, to serve narrow political purpose. So I am skipping from here this point, very important point to mention, that when consultation as a word was misused, then Supreme Court started a convention and ruled first judge case, second judge case. I will come to that point some other topic. And they ruled further that it is consultation is not just consultation, it is in concurrence. So whatever advice Chief Justice is giving, it should be binding. Then a culture started when the Chief Justice of India and 4 other judges of Supreme Court, they formed a collegium and they started recommending the judges to executives or president, and president has to appoint a judge from that name suggested. So collegium took to themselves the power of appointment. This was challenged in the court so many times, but court ruled that collegium system should continue, because if the power to appoint the judge comes to executive unilaterally, it can be misused. It had been done in the past also. And A. N. Ray was the person. He had invited a judge conference, a meeting of the judges of Supreme Court, that he is going to form a bench, constitutional bench, larger than the bench of Keswanand Bharti. And I will again mention that when Keswanand Bharti judgment was given, the total strength of judges of Supreme Court was 14 and 13 judge bench sat there. Emergency period, this number was increased to 18. Then largest judge bench will sit. Larger judge bench will sit, and they will be review the Keswanand Bharti judgment. Imagine, A. N. Rai had invited the judges to form a constitution bench. For this purpose, he organized a meeting, but none of the judges turned up. And Nani Palkiwala, that time very popular lawyer, he had a very sharp comment on Indian judiciary that time. So, chances of misuse of power by executives in favor of them is there. There was gross misuse of this power. Therefore, what is the present condition? The appointment in India is done by collegium. Here, Chief Justice of India, CJI, plus 4 senior most judges of SC. They form a collegium, and collegium makes appointment. Got the point? This collegium is very controversial. It's very controversial. I will discuss about the issue areas in which I'll talk about this. But in what circumstance collegium took the power and today collegium prevail? This circumstance I discussed with you. There is no other country in the world, especially I'm talking about liberal democracies. No liberal democracy in the world where judiciary makes appointment of the judges by themselves. Here they don't make signature of appointment, but their view prevail. It means they appoint. Executive just give a rubber stamp like signature. They can delay that process, but they will have to appoint the person which has been suggested by collegium only. They can't put their name. They can't bring their name. No, don't appoint this person. So third is appointment of the judges. It's not as per constitution but as per convention. Fourth thing which makes judges independent. So their salary and allowances and official expenses also charged upon consolidated fund of India. Means it is charged expenditure. I will discuss the budget. I will discuss about what is charged expenditure. For charged expenditure, voting cannot be done. Voting cannot be done by legislature. They can't vote. So first what they do when budget is passed, they vote the grants or demand for grants. So every ministry's demand for grants are voted. So money has been given to every ministry in that demand for grants. So once it is voted, then the charge expenditure like UPSC's members also salary expenditure charged, CAG salary expenditure charged, Election Commission salary expenditure charged, Constitutional Office whatsoever their salary expenditure charged, and they are clubbed together. They are clubbed together. And then it is voted as appropriation bill. So appropriation bill voting is done. Their salary is not voted as. So appropriation bill if not voted, it means not just the salary allowance of judge will remain unavailable, even the expenditure of department ministry will be unavailable. So if department is passing their expenditure, they will have to club these expenditure which is charged upon CFI, and then appropriation bill is passed. So it's charge expenditure. Not charge expenditure is not to be voted. Okay. So salary and allowances are charged. Then conditions of service. Cannot be made to their disadvantage during the term of their office. It's very important point here. Condition of service like the tenure. They can be appointed for 3 years or for 5 years. Second, what kind of remuneration change they will get. Third, housing, the post-retirement benefits, or in what way, in what process they can be punished. This condition of service of constitutional authorities can be changed. Parliament has power to make change in the condition of service of the constitutional authorities. But when they make change, this change will apply to newcomers, those who have not joined. It will apply to person who will join after that change has brought. So once they become constitutional authorities, their condition of service can't be changed. So they retire, after retirement they will get the benefit. It will not be applying to them. It will apply to newcomers. Means during the term of their office, their conditions can't be changed. Condition of service can't be changed. It will continue. So this is a very important tool by which executive can control judiciary. And they can fear that if we don't favor Prime Minister, Council of Ministers, or union government, they can bring a law, they can change our service condition, they can reduce our service tenure, they can give us punishment, post-retirement benefits. So it's very important. It helps in holding a constitutional authority independent. So they will be working without fear or favor, because on financial matters they are not dependent, on service condition matters they are not dependent. So even if executive wants, like suppose working government does not want proper audit of their expenditure so that some scandals or scam can be hidden. To hide scams and scandals, they don't want audit. What they can do? They cannot provide for budget to CAG's office or reduce their budget. They will have less employee. They will not be able to complete the auditing process. Then government can be safe. And what they do in case of CBI, the CBI judges or CBI has courts. Number is very less. The less cases they can handle. And government can, CBI can choose some of the cases. They can't take up all the cases. And that cases which they can choose, out of 100 cases, they can go investigating and trying 3 cases, 5 cases, 10 cases. Then the finance determines how many cases CBI can handle. Then how many cases CBI can handle, it means if cases are less, then government can intervene that which cases to pick. And which cases to pick can decide the political rivalry, personal grudges, or working CBI in narrow personal purpose. So finance is very important tool. No, salary allowances, which seems to be very simple component of the independence of a body, that's very complex and very sensitive thing. Okay, so these are some of the conditions which find in the constitution. Apart from that, for judiciary, so they have power to punish a person for contempt of court. Contempt of court. Contempt of court is one of the exceptions to natural justice. So what are the exception principles in natural justice? This principle is contempt of court. Here, court can hear cases against themselves and can punish a person if it insults or derogates a judge. So if a judicial member is derogated, means his dignity is striked upon, then the judges have power to punish a person. So contempt of court power given to the judiciary, by which judiciary can keep people beyond judicial uh, unwanted rivalries. So contempt of court as the power of the court makes court neutral, because whenever executive or legislature may try to derogate, go against dignity, or criticize unnecessarily, or take a particular judge personally against him, then court can take recourse to power of punishing for contempt. So this power is controversial because it is nemo jude in causa sua violated, but it is exception. There are certain exceptions which is not which is applied in case of judiciary also. So contempt of court is very powerful tool. So many people are punished when they go against judiciary, when they write against judiciary. But said this power should be used with restraint. Like one the journalist criticized a judge in Madras, Chennai, Tamil Nadu. Then Madras High Court took recourse and punished him. Same thing happened when Prashant Bhushan started criticizing the judges. The judges had to punish him for contempt. But judges knew that Prashant Bhushan is a senior lawyer, appears in various cases, tries to bring reforms in government. His father was also very sensitive in this matter. They wanted judicial reforms also, judicial accountability they preached. Then court imposed 1 rupees fine upon him. It was a symbolic punishment given, but punishment is given by the judiciary. So punishment can be given by judiciary. So judiciary cannot be criticized, individual judges cannot be criticized for narrow purpose, for giving certain neutral judgments, for preserving the rights of the people. If it is done, then judiciary has power to punish those people. The judiciary, by applying this power, contempt of court related punishment power, judiciary can secure its neutrality, preserve its dignity. Got the point? So we have how judicial independence is maintained in case of India. Judiciary derives its power from constitution. Removal of a HC judge is difficult task by special majority. Okay. And even appointment done by collegium, convention says this. Salary allowances charged. Service condition cannot be made to their disadvantage during term of their office. And they have power of contempt of. And some other minor elements are there for judiciary. It's less like they are not eligible for government posts positions after retirement, but that is less significant because nowadays judges are interested in politics also. Judges can become governor, judges can become president, judges can take some the other post outside government. That is very significant. One of the judges, judge from India, he left the country, he joined the international court. Some judges join other arbitration boards outside the country, etc. So this idea is less relevant, but still they are ineligible for future government appointments.